Awesome, Kevin. Thank you for muting everyone. I appreciate that. Thank you so much for being here. My name is Andrew Doyle. Of course, thank you, Kevin. Thank you, Century 21 Edge, and thank you, FLA21 Experience, for an amazing event and for inviting me back. Most of all, thank you to all the agents and brokers that are on our kind of follow-up today. If you guys were on my agent session at FLA21 Experience, you heard me say, well, I was going to talk about X, Y, and Z, but this morning things changed. Today, we're going to get even deeper into what exactly changed, specifically the buyer-broker agreement. So I call this class EBBA Rising, the new buyer-broker agreement in Florida. A little bit about me before we get started. What do I do? I'm a business and real estate lawyer. That's it. That's all I do. Very focused practice. I always say I break things up into 3 buckets: dirt, paper, and money. If you have not yet had a chance, I do invite you to give us a follow on Instagram at Orlando Lawyers. We put a whole bunch of content on there. We're working to get all of our classes scheduled and things like that. I do a lot of agent education and training. Phone number and direct email, that is my actual email. Because I am a contract lawyer, I would not be much of one if I didn't give you a disclaimer. So here we go. All content herein is being provided for informational and educational purposes only, should only be utilized for that purpose, is not intended, nor should it be construed to be legal advice as to any particular scenario, situation, objective, contract, relationship, and/or transaction. Every legal scenario and every real estate transaction or contract is unique. Couldn't do it in one breath, sorry. And specific legal advice should be obtained based on the facts applicable. What am I saying here? What I'm saying is this. We're talking about a new form that came out. I'm sure you all have a ton of questions, specific, unique questions about, hey, what do I do in this scenario? What do I do in that scenario? I want to get you answers, but they're all in the context of information and education, not legal advice. Keep in mind, a single comma, a missed digit, an extra zero makes a big difference in a contract. So always, always, always err on the side of caution. Okay, boring stuff out of the way. What are we talking about today? Let's start with the overview, okay? 3 things that I want you to keep in mind. Center of the screen, we're going to do a quick review of the NAR Settlement BBA rule, right? I'm not going to go deep into the settlement itself. We're going to focus on the buyer-broker agreement rule, the change, and how that affects agents and brokers here in Florida, okay? Only Florida, because what I learned at FLA21 is that a lot of brokers from other states like Virginia and Washington, they're saying, what, you guys don't use buyer broker agreements all the time? You don't have to? We have a state law that requires us to do that type of stuff. So we're going to be talking a lot about how to use these buyer broker agreements, particularly the new form here in Florida. We're going to do a deep dive. So I'm going to tell you now, it's going to be a little tedious. Make sure you get the Keurig going and you have plenty of coffee to keep you awake. It is the boring part of the presentation, but it is the meat and potatoes of it. It's what we need to know. We're going to compare and contrast the old one versus the new form that came out on July 9th. And then we're going to wrap up with best policies, practices, procedures, stuff like that. And there's going to be some time for questions. So moving forward, feel free to drop questions in the chat. I'll do my best to keep an eye on that on the chat as we move forward here. If I can answer it while I'm talking, I will. If not, hopefully we'll be able to get to it on the back end. And I'm going to shut up and start teaching. Okay, so as a refresher, right, the NAR settlement, we all know what happened. There were 5 main things that came out of the settlement, drawing your attention to the bold in the center of the screen. There's now a requirement for written agreements. So there's a NAR rule that is now going to require buy-side MLS participants to have a buyer-broker agreement before showing or touring the home. Original effective date for that was right around now, mid-July. That's now been pushed back to August. I believe local here in Central Florida, local Stellar MLS is expecting to deploy this rule effective August 6th. Don't quote me on that one, but it is at some point ahead of the actual deadline. So we're about 3 weeks out of this stuff. Okay, so it's in that vein that we're talking about. So what's the latest? We have this policy change, like I said, that got pushed back to August 17th. There have been a number of form updates in Form Simplicity from Florida Realtors. On June 23rd, Florida Realtors released 2 compensation agreements and 2 modification agreements. Those agreements are really, they memorialize a seller to a broker. If a seller is in and of themselves promising to pay the buyer's broker commission, there's an agreement for that and a modification for that. We're not going to be covering that today. And then The more common scenarios where seller broker is going to be splitting the commission or sharing the commission with the buy side. There's an agreement for that and a modification for that. That's not earth-shattering. And by the way, neither are the changes to the EBBA, but we do need to know them. And like I said, on July 9th, so last week, the new EBBA, when I say EBBA, I'm talking about the EBBA, the Exclusive Buyer Broker Agreements. If you are not familiar with the forms in Florida Realtor, the Florida Realtors forms, excuse me, if you look in the bottom left corner of all the forms, there's always a form number. And that form number helps you know if you're using the current version or not. Now, when we talk about buyer broker agreements, particularly these, it is super, super important that you're using the current version, because there's some stuff that has to be in this new version that has never been in the old version, and it must be in there to be compliant. So please, 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 please make sure you are using the EBBA 7TB, 7SA, or 7NR. So it's version 7. That's the one that you need to be using, the version 7. Those are the ones that were released on July 9th. Okay. So common question that comes up here is kind of a threshold matter is, what about the existing buyer broker agreements and listing agreements, right? The world doesn't stop because practice changes are coming in early August. So all of you are doing deals right now. And some of you may be doing deals with buyer broker agreements that have been in place before July 9th. Obviously, you wouldn't have the new form before July 9th. There may be listing agreements that predated this. I'm sure there are listing agreements that predated this whole thing. So the problem here is, do those existing ones get grandfathered in? The answer is no, they don't. They may very well not be. And if in the case of buyer broker agreements, they are not going to be compliant if you're not using the new form. So it's a good practice to just say to your buyers that have already signed an existing BBA, hey, we need to update this. There's a practice change coming out. I'm not changing any of the terms. I'm not upping the compensation or anything like that, but we need to use the new form. So super, super important that you use the new form. And I'm going to just tell you guys right now, while we're talking about it, why it's so important. One of the requirements that came from the NAR settlement as it relates to the buyer broker agreements is that there be 2 conspicuous disclosures made. One that says commissions are fully negotiable, and one that talks about caps on seller commissions, on sellers' offers of compensation relative to what a buyer's agent is going to get. In other words, those 2 things need to be very clearly and explicitly disclosed to the buyer in these buyer broker agreements. The new form does that for you. It's pre-printed in there. But the old one didn't have any of these things. That's why you need to make sure that you're updating them. So the takeaway from this slide right now is, if you have one in place, use the new form, update it. You don't have to wait. They're there for you to use. You might as well do it now, so it's less work come early August. Okay. Let me make sure I have the chat open. Okay, I got the chat open now, so I can keep an eye on things as we're moving forward.
I'm watching it too, Andrew, so I'll
awesome.
pop in if there's
Thank
anything.
you, Kevin. Appreciate it. Okay, so what do the EBBAs need to say now? So, if you need any additional information, NAR has this resource that perhaps you haven't heard about it. It's facts.realtor. All the information is there. That's straight from the horse's mouth, so that's the best place to go. But there are 4 things that all EBBAs need to say. Now, again, I'm going to stress the fact that the Florida form that was released by Florida Realtors satisfies these obligations. So you don't have to add anything to them. You don't have to play with the language. In fact, I encourage people not to. But so that we understand what the lay of the land is, this is what was required as it relates to the buyer broker agreement. So 1, there has to be this specific and conspicuous disclosure of how the compensation is determined. Sorry, I see a question in the chat. Does this also include EBBA 7TN form? Yes. So Ronnie, thank you for bringing that to my attention. So when I say there's EBBA 7TB, EBBA 7SA, EBBA 7NR, the TB, the NR, the SA, those relate to the broker agency relationship. TB, transaction broker. SA, single agent. NR, non-rep. The reason why that's important is because the capacity in which a buyer broker is working for a buyer changes depending, and the duties change depending on the relationship. If you're a single agent, you owe an absolute duty of confidentiality, for example. You can't rep both sides. You have a duty of loyalty that you don't have as a transaction broker. So my point is the form has to be different. So just make sure that you're using the right form for the right brokerage relationship. Great question. Thank you for keeping me on track. Back to what NAR said about these BBAs. We need this conspicuous disclosure of how compensation is determined, how it's going to be arrived at. We all know how it's arrived at. It's a percentage of the purchase price. That's not rocket science. Number two is the amount, right? And this may seem odd, right? Why do we have to disclose the amount? We always disclose the amount, yes, but it can't be open-ended. It can't be determined on a number of different things. It's 3% of the purchase price based on $300,000 or whatever it is. That's it. Again, the form does it for you, so you don't have to play around with it. Third thing, and this is important for buyer's agents to know, is that the settlement requires that the buyer broker agreements have basically a cap on the max amount that a buyer broker can get as a commission. And essentially, it's whatever you put on the form. So if it says you're going to make a 2% commission off the purchase price, then you can't take your 2% that you get from the buyer and then go to the seller and then get another 2%, because that's 4%, which is more than the 2% that you have on the EBBA. So you need to understand that you can't double dip. You can't get compensation from the seller and then add that to the buyer. You can never make more on a deal than the amount specified on the EBBA. Now, some of you may be saying, well, I don't want to sell myself short and go under contract with a buyer to make 1.5%, but then be offered 2 on the sell side. Why would I do that? You wouldn't, which is why I encourage brokers to have a meaningful conversation with their agents and kind of develop a policy brokerage-wide that says, look, all of our BBAs are going to have 2%, 3%, whatever it is. Remember, you can always take less, but you can't get more. In other words, if your BBA says 3%, but there's only a 2% offer from the sell side, and your buyer can't afford to pay the extra 1% out of pocket, they may be contractually obligated to do that, but it's within the broker's discretion to say, look, 2% is fine. We're not going to come after you for the extra 1%. You can come down, you just can't go up. So you don't want to sell yourself short by only putting 1.5 or 1 or 2 or whatever, with the possibility that you may get more on if there's an offer of compensation made outside the MLS. And then the fourth thing that NAR said that these BBAs have to say is there has to be this conspicuous statement that broker fees and commissions are not set by law and are fully negotiable. Surprise, 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 right? We've always known that these commissions are negotiable. People just haven't exercised their right to negotiate, which is what led us here today. But the fact remains that you need to have those disclosures. So like I said earlier, the reason why the version 6 forms don't work is because they don't have these 2 disclosures. If you're using a version 6, it's not going to be compliant come August. Okay, so moving right along. When is the requirement for the signed EBBA triggered? This is real, like, deep in the trenches practice stuff. So if you're primarily a buyer's agent, this is going to make a lot of sense to you. The change per NAR, right, per the settlement, requires that written EBBAs be in place, written and signed, not just in writing, but signed by all parties, when 2 things. The MLS participant, so the buyer broker or the buyer's agent, is working with a buyer and the buyer is touring a home. Okay, so we got to break down those 2 terms. What does it mean to be working with? It's pretty common sense, right? What does a buyer's agent traditionally do? They identify properties, they arrange showings, they facilitate negotiations, they submit offers, right? What does it mean to be a buyer's agent? If you're doing that stuff, you're probably working with the buyer, which is a good sign that you need an EBBA in place. Secondly, touring. What does it mean to tour a home? Well, obviously it means to do a showing, right? But Interestingly, it also includes virtual showings. So virtual showings are not an exception, right? In other words, the term touring doesn't require physical presence at the property by the buyer's agent. Put another way, you could be a Miami buyer's agent and have someone here in Orlando that wants to buy a $10 million listing in Windermere or something like that. And you do a virtual showing, or you send someone up here and they do a virtual showing, whatever. Like the relationship is there. Let common sense be your guide. If you feel like you're working as a buyer's agent, then you probably are, and you need the written EBBA. My advice is to just err on the side of caution and say, look, if you're helping people find properties, even if you haven't reached the offer stage, even if you haven't yet done a showing, if you're identifying potential properties, if you have them on an MLS listserv, you're communicating with listing agents but haven't gotten there, you need that buyer broker agreement. I would even go a step further and say, look, what's the tone of this relationship? Am I going to represent you? Yes. Okay. Here's the buyer broker agreement. That, to me, as an attorney representing buyers, representing brokers and agents, as general counsel, is the right time. That's the appropriate time before the relationship gets too deep. Now, there are some exceptions, right? And these exceptions, when we drill deep, they make a lot of sense. The first one is this open house or open door or door open exception. And by open door, I don't mean iBuyer open door. So if you're encountering a buyer at an open house, if you're a listing agent and you're doing an open house, you don't need a buyer's broker agreement for everyone that steps in to see it. That's just not reasonable, right? You can't run to the threshold saying, wait. You can't come in, you can't see it unless you sign this, because then you're actually pressuring them to hire you to represent them. And that's no bueno. So you don't need a buyer broker agreement simply by being an open house listing agent. What you do need to pay attention to is when the relationship shifts. They may come in, they may tour the home, and then they may talk to you about the price. That's fine, right? You're talking about list price. You're still working for the seller. But the second they say, hey, I would like to submit an offer. Can you help me? Yes, here you go. It's a copy of the buyer broker agreement that I will need that signed. You need that signed. Period. End of story. Okay. So I'm not seeing any. Oh, I see a question on the chat. If husband and I want to buy a house and I'm an agent, who should we put in the EBBA? Both of us. Okay, interesting question. Well, if you are going to be collecting a commission on the sale of the property, then you would, if both of you are buyers, then both of you would need to be parties to it. Now, also keep in mind a couple things. One, it's not an agreement per se between the agent and the buyer. It's really an agreement between the buyer's broker and the buyer. So if you're a broker, then yeah, it's a weird kind of agreement with yourself. But under normal circumstances, you may say, well, we don't really need that because who are we going to sue? But this is a compliance thing. It's non-negotiable. And particularly since you would, in that scenario, hold all the cards and you would have the decision whether or not you want to sue yourself. Not that you would. But my point is, right, you have all the discretion. It's never going to be an issue. So just go ahead and get it executed so you have it on file so that you're always in compliance. Because remember, this is a compliance thing. It's a practice change. All MLS participants must have one in place. But that is an interesting question, Polina. I appreciate that one. Okay, moving right along. There are some other exceptions. We already covered the open house exception. The listing agent hosting the open house, we covered that one as well. It's the key there is when you're a listing agent working for the seller, you don't need an EBBA. But those relationships, if you've ever done an open house, the whole idea really is to sell the house, and a close second is to attract buyers. So in an ideal scenario, if your open house is working, you're attracting people that may submit offers, and ideally they're going to have you submit the offer, right? So you've got to really pay attention to when the relationship changes, and it can change on a dime in seconds in a conversation. My advice, if you're going to be a listing agent with an open house and you may be repping the buyer as well, you're definitely going to want to have a stack of pre-filled buyer broker agreements with you at the open house. Just like you have the MLS printouts and the Dunkin' Donuts and the water, you want a stack of those documents there ready because you want to be able to say, here you go. Happy to help. I can submit that offer for you as soon as the open house is over. I need this signed. Perfect. Yeah, I see a comment in the chat is a good perspective to keep in mind is compliance first. Yeah. I'll do a little bit of, I'll digress just a little bit. We don't know how these are going to be, how aggressively these new provisions are going to be enforced. The MLS and local MLSs have initial kind of enforcement responsibility here, at least when it comes to the listings. The legal issues, the lawsuits that may arise from violating these practice changes, those are the ones that I'm most concerned about, because one way or another, someone's going to be spending a bunch of wasted money on attorney's fees just to be the first person in to make the case, so to speak, right? The test dummy. There's got to be someone that brings this case, that challenges these things and ends up with an opinion that all future cases follow. So if you don't want to be that person, best place is just to put compliance first. I see another question. So if you show off-market properties to potential investors, but you represent the seller, do you need a non-rep EBBA? So great question. If you are not representing those buyers, those potential investors, and if they have their own buyer's broker, you probably don't need the non-rep, but it doesn't hurt to have one in place, just the non-rep disclosure showing that you do not represent them. But yeah, if there's no brokerage relationship, then you need the non-rep. That's going to be version 7 NR. Okay. Oh, wait, did I miss one? Listing agent communications with prospective buyers. This is also another common pitfall. If the communication occurs as a listing agent working for the seller, then you probably don't need one. And this is the same thing I've said about 3 times, just a slightly different way in a different context, right? If you're the listing agent and what you're doing is purely for the seller's benefit, you don't need an EBBA. But the second that they say, hey, I want you to submit an offer, stop. Don't even submit the offer. I wouldn't even talk to them about their terms. Get that EBBA signed. You do not want to be on the wrong side of this, because even though I'm an attorney and even though I take cases to court and I represent brokers, this is uncharted territory. The best I can give you is a crystal ball. And we all know that if I had a crystal ball, I wouldn't be here. I would have won the lottery 3 times and I would be living in the Cayman Islands by now. But the fact remains that we don't know how this stuff is going to shake out in court, how these practice changes are going to be challenged. And because we don't know, we have to err on the side of caution and be safe. Limit liability on ourselves and our brokers and our brokerages. Okay, I have sufficiently beaten that horse to a pulp. So, not seeing anything else in the chat, I'm going to keep on chugging. And by the way, you will all get the slides if you want. I believe Kevin already has them, and if not, he'll have them shortly from my office. So you'll have these to reference. Just keep in mind the disclaimer. It's only for informational, educational purposes. Okay, so I tried really hard to keep everyone awake. I'm going to try really, really hard to keep everyone awake to the next session, but this is going to be boring and tedious. So don't worry. Again, you're going to get the slides, so you have all this information. Just kind of listen, and if you need clarification, drop the questions in the chat. So what we're looking at here is a summary or an overview of the changes from version 6 to version 7. Version 7 is where we're at now. There are, like I said, these new disclosures regarding commissions and whether or not they're negotiable, and then the caps on the commissions like we talked about. Now, there's also this mandatory reduction in buyer broker compensation from the seller's offer of comp. Now, that's always been there. In other words, the prior versions always kind of said, look, whatever amount the buyer broker is entitled to based on this document, it'll be offset or credited against whatever the seller's offer of compensation is. That language has just been revised for clarity purposes in this one to make it really, really clear. and I also believe it's been revised to help defray steering claims, although I don't think it's going to resolve them in its entirety. Okay, something else that happened in the new version, the retainer provision. There was always an language, well, it wasn't always, but version 6 had language regarding retainers and whether or not a buyer broker could collect a non-refundable retainer. Not a common practice. It's kind of a tough sell to a buyer, just kind of as a function of the way real estate sells. It's difficult oftentimes for buyers to come up with a retainer. But it was always there in version 6, and it's still there in version 7. But now it says that that the retainer is in addition to any compensation earned by the broker. Now, I've thought long and hard about how this mechanically would work out. I look at this retainer function in this new version, in light of the changes, as kind of a way for a buyer broker to make sure that they at least get something, or the buyer's agent to make sure that they at least get paid something, right? It might be a $500 or $1,000 retainer, and the language says it's non-refundable, and then that is above and beyond. And at least that way you get that up front, so you know that you're not quote unquote working for free, right? One in the hand is worth two in the bush. That's where I think this new section is going to be most used, is brokers that have a policy of saying, look, we don't know if these buyers are going to have money come closing to pay their out-of-pocket, to pay their closing costs and stuff like that. So we want a retainer up front. And that's going to be in addition to compensation. There's some flexibility here in structuring fees that I think perhaps buyers brokers didn't use in the past. Another change, I'm sorry for the typo there. Another change is that now the property description and the price range, there used to be a section, I believe it was section 3, that had you describe the property, you know, how many bedrooms, how many bath, townhome, single family, so on and so forth, and then set out the price range. All that's gone. And that has the practical effect of saying basically any property, any residential property, which is 4 units or less, is now going to come under the scope of this agreement. So that's helpful. As I say that, I don't want anyone to look at this EBBA, this particular one, and see it as more work. Believe me, I see this new version as Florida Realtors' most able attempt at helping buyers, agents, and buyers brokers perfect and secure their rights to a commission. There are things that have been built in here that help buyers brokers get paid, and help make sure that buyers brokers will get paid. One of those examples is the retainer provision. Okay, so there's also greater distance between the buyer broker and the buyer when it comes to the buyer's financials. The old version had a pretty close nexus between the information that the buyer was going to share with the buyer broker and the financing and things like that. So if you really go line by line and you look at those sections, you'll see that there's a removal of any of the discussion of the financial transactions. And I look at that as a way to distance the buyer broker from the buyer's financial scenario. In other words, it doesn't matter, right? This is purely one of contract. You hire me to identify properties and submit offers and see the contract through to closing. Period. End of story. I almost don't care what your financial situation is. I don't want to be overly involved in it. And a lot of agents do get overly involved in that. They start talking to lenders. They start sending them to different lenders. They say, hey, check out this lender. It turns out it's a spouse or a cousin or a brother or something like that. So that language has been removed from this EBBA, and I see that as a boon or a boost to the buyer broker when it comes to enforcement. I think that the single most significant change here, in a geeky legal way, on this new EBBA is the buyer's obligation of good faith effort to perform on the contract. This is an entirely new section that was just added. It's section 5, subsection G. And it literally says that the buyer has to act in good faith and use diligent effort to close on the contract and perform the obligations. Now, why does that matter? Because and we're going to talk a little bit more about that in a few minutes, but basically that creates a breach of contract action on the part of the buyer's broker in the event that this buyer entered into this agreement in bad faith. with no intent to actually pay the buyer broker, the buy side commission out of pocket if necessary. So that's a huge help when it comes to brokers who need to enforce these agreements in contract in a court of law against a buyer who bails on it. There's a default of 30 days on the protection period. The protection period is not a new term. It was kind of a cooling off period, so to speak, after the agreement was terminated. There was a period of time where if the buyer dropped agent A and went with agent B and closed a house that agent A had showed to the buyer during the term of that agreement, agent B closed it, agent A is entitled to that commission. Put another way, agent A's commission is protected during that period of time. There was just always a blank. And because there was a blank and there was no default language, a lot of agents skipped over that and just didn't put a term in there, meaning that if court would look at that and say, well, there's no term, meaning you have no protection period. So now the contract actually defaults to 30 days if you don't put anything in there. I think 30 days is a little short. I would probably put 60 or 90 days in there, but side note. I see a question on the chat. So to be clear, the greater distance finances is only in regards to this agreement, not in the things we learn to craft offers and negotiate on their behalf. Yeah, when I say there's greater distance, and perhaps I shouldn't, I don't want to misdirect anyone. My point is, when I'm reading into this, I'm looking at this and I'm saying, oh, that's an argument that I would make in court. And I would argue in court, judge, look, we had nothing to do with their finances. Their finances were so far removed from this. This is a straight contract issue, no big deal. Like, they owe us this money, period, end of story, right? I want to be able to make that argument because it makes it for a cleaner enforcement action. So when I say there's greater distance, that's what I'm talking about. But yes, correct. It doesn't have anything to do with crafting offers or anything like that. There's no requirement that you don't know things. I'm just looking at it from a lawyer's enforcement perspective. Two last points here before we get into the nitty gritty, if you're still awake. There's now an addition. There's a cancellation fee line that has been added to the protection period paragraph. Now, what this basically means is the buyer can terminate this agreement for X dollars, whatever's in that line. And that's another hedge for the buyer broker to make sure that they don't just completely do all this work and get no compensation or no payment whatsoever. At least you have that cancellation fee. How much that should be, that's largely up to the brokers. And again, that's something that I think brokers should install in their policies and say, look, every agent in our office is going to have 30 days or 60 days on the protection period and $2,000 cancellation fee. That helps resolve these disputes if the buyer wants to terminate. You can't force them to let you work for them, but you can hold them to a cancellation fee so long as it is clearly written in the contract, and this does it for you. Last thing here is, and this is a significant issue for brokers that may be enforcing these agreements. They used to be, EBBA version 6 had a mandatory arbitration provision. In other words, no matter what, it had to be you had to go to arbitration. Quickly, the difference between arbitration and court is that arbitration is private court. Public court, we know, circuit court, court is paid for by taxes, by tax dollars. So you have judges and, courtrooms and things like that. Arbitration is very, very expensive and it's paid for by the parties. So that means that in a mandatory arbitration scenario, if a buyer's broker has to enforce a $5,000 commission agreement against the buyer, they may end up having to pay $3,500 filing fee just to get the case to arbitration. So before you have a chance at success, you're $8,500 in the hole. Doesn't include your attorney's fees and costs and time and all that other stuff. Compare that with what it might cost to file that lawsuit in circuit court, probably about $500. So it's significantly less expensive to litigate than it is to arbitrate. Arbitration oftentimes favors businesses, and yeah, there's pros and cons to each. But from my perspective, In my practice, I prefer to litigate. I find it to be less expensive and I find it more predictable. That leads me to advise my clients a little bit better. So I like this change. In other words, mandatory arbitration is no longer mandatory. A box needs to be checked if you want to go to arbitration. If not, it's going to default to court. Okay. See, 2 quick questions. In that case, the protection period is like taking a listing that was previously listed and having buyers on an exclusionary list. Agent B gets 0. Not necessarily. The protection period is a period that protects the party that has the buyer broker agreement. So if you run around showing 10 homes to a buyer during a 3-month period on a BBA that has a 30-day protection period, and they terminate, 30 days from that day is the period of time where if they close on one of the homes you showed, you're entitled to a commission. That's the purpose of the protection period. It protects you from buyers who bail on you and go somewhere else. It doesn't necessarily result in cutting out the second agent. My experience leads me to generally advise brokers to just work it out with the new agent. Say, hey, look, I showed him this property. Here's the proof of it. Send me a referral fee, or let's split the commission, whatever. We're all professionals here. That's the right way to resolve it, not going to court. Sometimes you have no option, but yes, technically it would cut out the second agent, although rarely does it ever do that, because usually that second agent has to do stuff in order to get it across the finish line. So they would be entitled to some compensation. I see another question here. I just put an offer for a buyer yesterday and I don't have a buyer broker agreement. Should I have the buyer sign the buyer broker agreement? No. Well, technically, we're not inside the practice change deadline, so you don't have to have it in Florida. I always advise that every buyer's agent have every buyer sign a buyer broker agreement. So my answer to that question is yes, you should have that buyer's agent sign it now. Run it up the chain of command at your office, and make sure that your broker approves of the forms. How would you know if they bought a property with another realtor during that period? You have the MLS, you can watch, what you showed them, and you can follow up. Generally, agents that have these agreements terminated on them have a feeling that the buyer is going somewhere else. It's also a small world and a small community. Agents talk. You may actually know the person that they dumped you for and went with. Sometimes you get the common courtesy of getting the call from the other side and says, hey, look, I'm working with your buyer here. Did you have that terminated? So how would you know? You would only know if you knew, and you can know if you follow up on the MLS, on the properties that you showed them, things like that. Truth of the matter is it may slip through the cracks and you may never know. And another question, it has to close within the protection period, not just be under contract. Correct. Yes. And yes, you're right. That's why I always say 60, 90 days. Okay. So that's the summary. It was a detailed summary, and believe it or not, we can get even more detailed. So here we go. If you were, because you will get these slides, if you want to do a little bit of self-learning, bust out version 7 of the EBBA, print it out, and go through these slides section by section, and you'll see exactly what I'm talking about. Section 1 of the EBBA, this is the part at the beginning where it's identifying who's who, right? Buyer language doesn't exist. We're no longer actually talking about buyers. I'm not really able to drop that vernacular. It's just kind of ingrained in my head. But technically, under the buyer broker agreement version 7, you're not dealing with buyers anymore. You're dealing with consumers. And I think that change, and you're no longer dealing with sellers, you're dealing with owners. So as we go through these sections by sections, you'll see sometimes I have an analysis here. This is my personal opinion of why we're seeing this change, right? It's not professional. It's definitely not legal advice. It's just what I think is happening, my gut, my instinct. So my instinct here is leading me to believe that this idea of changing the word buyer to consumer and seller to owner, it's helping to recast this narrative that we've heard since the Sitzer-Burnett case went to verdict on October 31st of last year, and since March 18th, I think it was, when NAR announced the settlement terms, right? This is a consumer issue. So we're now seeing Florida realtors lean into that language, and now we're picking up on they're no longer buyers, they're consumers. Section 2, irrelevant, doesn't have any, there was no change in the version. It's identical from version 6. Version 3, this is the property description. This is the price range. This is the pre-qualification stuff. This is the section in version 6 where the buyer's broker or the buyer's agent would outline the parameters for a property that if it closed, they would be entitled to receive compensation on. It used to be you would have a price range of $400,000 to $500,000, meaning that if it sold for 6, maybe you weren't entitled to a commission. If it sold for 3, maybe you wouldn't. Sometimes those weren't issues, but contractually speaking, you wouldn't, because it kind of created a box. The new version removes that box. So the inference then, the legal inference, the way a court would likely look at this is, well, any property, particularly any property that this agent showed this buyer, falls under that category. Again, the removal of the price range and the pre-qualification, the communication with the lenders, all of these things that were in the old version, those have been removed, which helps distance the broker from the consumer or the buyer or the consumer's financial situation. Remember, this whole antitrust consumer thing, this whole lawsuit, all of this, it's left a nasty taste in the mouth of a lot of buyers and sellers and consumers. So now we're just kind of separating ourselves from it. Section 4, this is a significant one. This is the section that talks about broker obligations.
So they're manipulating what's going on.
This is the section, and by the way, if you don't mind, if you could just mute yourselves, I'd appreciate it. If you have any questions, drop them in the chat. Section 4, broker obligations. It removed the language that said that the broker is going to help determine financial capability and financing options. That's what the new version used to say. And if you read that critically, what that basically means is you're going to help review their finances with them and determine if they can afford to buy this house. It's helpful for you to not be obligated to do that. I've always thought it was a bad idea for agents to get a little too close to the finances, and you shouldn't have done that before anyway, but now the contract says that you are not doing that. So that's helpful. Also removed is the language that said that the broker's duties to the buyer remain even if there's an offer of compensation from the seller. That was resolved. That was resolved by other language, so not super important. The fair housing and the service providers language, that has remained the same. Fair housing is fair housing. We all know what that is. Service providers, this really talks about if you're a buyer's agent and they say, hey, can you connect me with a lender? That's what it is. It's connecting the buyer with another service provider or a title company or a survey company or a home inspection company. That's what that language is there for. But irrelevant, it didn't change from version 6 to now. Okay, moving right along, section 5. Remember, this is the one that I said had the significant change, and we're gonna get to that. It used to be called buyer obligations. Well, we don't have buyers anymore, so now it's called consumer obligations. This is an important paragraph because I think this paragraph is going to be where there's a lot of litigation that arises over these new buyer-broker agreements. Buyers agents that get shafted, so to speak, on these agreements where buyers bail on them and don't pay, and they enforce them against the buyers. This is where I, as an attorney, am going to look. I'm going to say, look, consumer, you were obligated by the contract to A, B, C, D, E, F, and G. You need to do all of these things, and you failed to do A, D, and G. So that's the basis of my lawsuit against you. Case in point, 5G. This is the language I mentioned a little bit ago. Now consumers. Now consumers have to make a diligent, good faith effort to perform the contract terms of any purchase agreement or a contract to lease and close on the sale of any property that the consumer contracts to acquire. Does that mean that if they have a failure of a finance contingency, they're in breach of contract with you? No. But it does mean that if they doctor their verification of eligibility or they misrepresent to their lender in an effort to get disqualified so they can get out of this contract, then yeah, that's a violation of the contract, and that's a breach of their diligent effort and good faith to close. So a lot of these issues really address these unsavory consumers and unsavory buyers, and these buyers that really hire you with no intent to actually move forward. They're out there, and if you've been in real estate long enough, you've probably experienced them. That language is a huge boost to enforcing these agreements. by the broker against the buyers. Section 6, this is the retainer. We talked about this. They bolded the word non-refundable. It was always there, but now it's bolded. Doesn't seem like a big deal, but trust me, it is. It's significant for me as the attorney to be able to go into court and say, Judge, take a look at this agreement right here, page 3, top of the page, non-refundable, bolded, 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 bolded. It says they're never getting their money back. It is a non-refundable fee. That's a much easier argument to make. Perhaps more importantly, the retainer agreements are now expressly in addition to any compensation received. I think the inference used to be there was some language that implied that it was, but it wasn't super clear. It's been made more clear, and now it clearly says that the retainer, the non-refundable retainer, is in addition to any compensation received, be it compensation paid by the buyer or compensation paid by another source. My analysis here, it essentially allows a broker to get that non-refundable retainer up front before there's a bunch of time and effort expended as a hedge against the possibility that the buyer chooses not to, or, due to circumstances beyond their control, is unable to pay at closing. Again, this is uncharted territory, and it's difficult for us to be sitting here saying, how could I possibly rep a buyer without knowing for a fact that they're going to pay me? You don't really know that you're going to get paid now under the current scheme, right? You don't know that the seller's not going to pull something, or that the listing agent isn't going to change something at the last minute and, you have to sue them for it. It doesn't happen often, but it could, because people may have, you may have a contract and everyone may sign it. It may be perfect and maybe 100% in your favor, but that people still have to curb their conduct in line with the contract in order for the contract to matter. So just keep that in mind. No matter what it says, reality could be different. Okay. Section 7, this is the section that really matters the most when we're talking about compensation. It's the compensation section. So the new version adds some language that really locks in that compensation, even when the buyer defaults on the contract. Now, a minute ago, I said, well, if they have a failure of a finance contingency, does that mean that they've breached their good faith and diligent effort? No. But if they default because they fail a finance contingency, they still may owe you the money that they are obligated to pay you for your services under the buyer-broker agreement. It's a subtle difference, but yes, when a buyer defaults on a contract, according to the new EBBA, they still owe their buyer-broker the fee in the buyer-broker agreement, which, to be perfectly honest, was true under the old version, but again, it's been refined. The new version also clarifies that the compensation is for brokers' services to buyer. Seems, why would you need to do that? Well, again, contextually speaking, we're working through this consumer confusion era where consumers don't seem to have any understanding of how commissions are paid. So this says you're paying me for the services I render you, not paying me for the services I render someone else, such as the seller. Again, odd that we would need to do that, but it is legally significant. It also clarifies that the broker's fee under the EBBA is due at closing, and closing is not a prerequisite. This is huge. And this is huge because when all of this first came out, there was a question of, well, how does the title agent know that they can cut a check to the buyer's agent? Because this is potentially different, right? Buyers potentially paying out of pocket at closing for their own buyer's agent services is not something that in Florida we're too comfortable or happens too often. So how are title companies going to make sure that the commissions get paid to the buyer broker? Well, this solves that issue and it puts it right in the buyer broker agreement. Boom, clear as day that the payment is due at closing. And I interpret this as, well, this is easy now. A title agent looking at the buyer broker agreement that's been fully executed knows you just roll it into the buyer's closing costs. There's a line item for it. Buyer pays out of pocket. Everyone moves on with their day. The math adds up. That whatever their closing costs are is what their closing costs are. Title company gets that and disperses funds accordingly. There's an additional fee provision that is left as a blank space, and this is really for like transaction fees and stuff like that. If your brokerage is the type of brokerage that charges those fees, those are administrative fees, not compensation. In other words, it's the cost of opening up a file and the internal CRM, stuff like that. They're legitimate fees. My analysis of this change to the compensation section is as follows. This is what I believe to be proactive litigation drafting. I teach real estate transactions at the law school, and the lesson I give every law student in my class is be a transactional advocate. In other words, you're involved in a closing, right? But advocate as if you're in court. Draft for the day in court, right? So I think Florida Realtors here is doing a little bit of transactional advocacy, and they're saying we're going to draft these provisions to help equip buyers brokers with some tools that will help them win these cases in the event that they have to sue a buyer on this agreement. So yeah, it's proactive litigation drafting. And I also think it smooths the transaction over because title doesn't need much more other than the obligation that it be paid at closing. I got a direct message, so that one will be kept anonymous, which form can be sent alongside an offer to have in writing the co-op compensation being offered by owner-seller. I love this question. Okay. Not super specific to what we're talking about here, but great question. In fact, the question says I mentioned it at the convention, but can't recall the name. Yeah. So the advice I'm giving every buyer's agent, I'm going to take a little diatribe here from the EBBA. The advice I'm giving every buyer's agent is when you're about to show a property, right? You already have your EBBA signed. What do you normally do? You find the listing and maybe you have 3 or 4 and you arrange the times with your buyer. You know, you're going to map them out in the whole 9 yards, right? And you call the listing agent and you say, hey, John, is property at 1234 Main Street available? Yes. Okay. Is there anything I should know about the property? No. Is it occupied? No. Can I show it today at 4? Yes. You already kind of go through those questions. Now I want you to add one more question to that list, which is the seller offering compensation? Is the seller offering compensation? If so, how much? Right? And the reason why you have to do that is because you can't see that on the MLS anymore. It's not going to be displayed. So you've got to ask. Now, this question is, what do you do to make sure that this listing agent that says 2% to you is actually obligated to make sure that you get paid 2% if the property closes? Well, what you do is this. They tell you 2%, you say, great. Email me your seller signed or your seller broker signed commission agreement. There's a commission agreement in the MLS. It's one of the forms that dropped on June 23rd of 2024. And it will already be signed, right? They send it to you and it says property amount of offer of compensation. Remember, all this has to be done off the MLS. This is why you have to have this conversation. If you're a buyer's agent, you tell them, okay, 2%, send me your seller signed commission agreement. And I will then, if my buyer submits an offer, send it back countersigned along with the offer. And if you think about it, that makes perfect sense. Why? Because you as the buyer's agent have already kind of solidified that commission issue. It's locked. It's set in stone. Everyone has signed it. Now, if the seller actually accepts that offer and the property closes, you have nothing left to negotiate. Everyone knows how much they're getting paid and everything is signed, sealed, and delivered. That document is what gets handed to title, so the title cuts the appropriate checks. Okay, so that's the question to the internal, to that direct message. I see another question. Is this something that may be able to be loaded into showing time? No. Absolutely, positively, 100% no. No discussion whatsoever on the MLS, in the realtor remarks, in showing time, in showing instructions, in an attachment to the MLS, nothing. No discussion whatsoever concerning compensation should be on anywhere on the MLS, any attachment or any software that's directly connected to the MLS. And that even goes as far as the IDX feeds that feed into your website. So absolutely not, no discussion. It would be nice if you're a listing agent, you could just preload that and say, just take a look at the attachments, but you can't. Okay. I gotta keep moving right along. There is a question. I'm gonna get to it. Don't worry. Section 8, the protection period. Remember I said now there's a default of 30 days, and this default is just the same as the other terms in like the FAR bar, Section 8 of the FAR bar. The default loan approval period defaults to 30 days if left blank. Same thing here. If it's left blank, you're left with a 30-day. I think 30 days is a little short. I like to shoot for 60 or 90. Section 9. What used to be called early termination, which is when the buyer cancels before the expiration of the natural term of the agreement, is now called conditional termination. Perhaps most importantly, it includes this cancellation fee, which we spoke about a little bit before. This is, what it costs for them to cancel. I equivocate this to being a tenant in a 12-month lease with a liquidated damages or early termination cancellation fee that says if I terminate at any time before the end of this term, the most I'm going to be on the hook for is 2 months rent. That's early termination, liquidated damages. Similarly here, it's a cancellation fee. It's the most that the buyer is probably going to have to pay in the event that they cancel the agreement. I like it because depending on how you work the numbers, right? If you're selling luxury, $1,000 cancellation fee isn't going to do anything because your average price point is probably $3-4 million. But if you have a proportionate cancellation fee relative to what you're doing, it'll really help hedge a lot of these bets. And at the very least, it makes your attorney's job a lot easier in the event that they have to terminate, because in the event that they have to sue, because that's the amount that we're going after. We're not going after something speculative. What would happen if this property closed? No, this is liquidated. We know exactly how much we're entitled to. It's the cancellation fee. Also, Section 9 was revised so that it now says that the consumer is responsible for full compensation minus the cancellation fee. Now, this may seem like it's going to conflict with what I just said, right? It does, and it doesn't. I'm going to be a lawyer here. I'm going to, walk the line. As an attorney, I always like to advise clients, look, let's go after the low-hanging fruit. It makes for an easier case. It's quicker to resolve if we don't have all these complex arguments to make. That said, if you have $1,000 cancellation fee, but you're entitled to a $30,000 commission, they're grossly disproportionate. It doesn't make financial sense to just lean into the cancellation fee. Why would you take the advice of an attorney that says just eat a $29,000 loss? No. But if your cancellation fee is $1,000 and you were only going to make $3,000, it probably isn't worth the attorney's fees to fight for that extra $2,000. That's what I'm saying. So this language allows the consumers it allows buyer brokers to hedge the compensation, subtracting the cancellation fee. It's just a way to resolve these lawsuits. And my analysis says that. I'm not going to belabor that point. Section 10, dispute resolution. This goes back to that arbitration clause. Remember, the old version was pre-printed mandatory arbitration. Now, if you want arbitration, you got to check a box. And some brokers really want arbitration, and more power to them. I don't really like arbitration. I find it to be very expensive, and I find that it's cost prohibitive. And I don't like it because it doesn't have the same rules of procedure and the rules of evidence that court has. That said, it's a litigation decision. It's a strategy decision on the part of the client. But the point is this: arbitration used to be mandatory. Now it's optional if you check a box. And also, there's now prevailing party attorney's fees provisions that are added for both litigation and for arbitration, meaning that if you win in arbitration, you can try to get your attorney's fees paid back. You're entitled to them. It's called a fee entitlement. And separately, if you sue in court and you win, you would be the prevailing party there. You have a fee entitlement. The day where the judge says, okay, John, you lost, you owe them $10,000 for the commission plus $5,000 for attorney's fees, open up your checkbook. That day never comes. That day never comes. It always ends up having to be a collection or a mediation, or some sort of post-judgment litigation has to arise. But my point is that the most salient point, the most significant takeaway here is arbitration is no longer mandatory. That's a big deal when attorneys are defending those things and an attorney sues in court, but had a mandatory arbitration provision. Not only did you waste your time and waste your client's money, but you ate their costs up because you have to dismiss this case and go to arbitration now. Now the box needs to be checked. That's an easy mistake to miss. Okay, so Section 11, this is the assignment and the brokerage relationship changes. Assignment means, the buyer can assign the rights just like they can assign the rights under the contract. No change there. And brokerage relationship, there has been no change under Florida statutes as to what constitutes a transaction broker, single agent, or non-rep. So therefore, there's no change to the language that sets out those duties. All that remains the same. Section 13, special clauses, now is referred to other terms. No change. It just has a different name. I really don't know why. Section 14, this is the last section. This is the acknowledgement section. And this is the real compliance section. Remember earlier I said your version 6 EBBAs won't be compliant come August. This is why. Because section 14 is what has the magic language. It has the conspicuous disclosures that are required by the NAR settlement, that all commissions are negotiable. It talks about the cap for the compensation for the broker. And then it has a rather confusing carve out for other forms of commission. It's sufficient for you to understand that you need version 7 to have a compliant buyer broker agreement come August 6th. And that is it. So I'm sure I've put a lot of you to sleep. I just have a few quick practice points that I want to go over, and then we have a little bit of time for some questions. Best practices moving forward here. If you're an agent, you got to be talking to your broker about this stuff. If you're an agent and your broker is not already training you on these EBBAs, there really needs to be uniform training across the brokerage, particularly if it has not historically been the practice of the brokerage to require buyer broker agreements to be signed. There's no shame in it not, because it was never required. Perhaps it was always a good idea, but it's never been required. It is required now. So now is really the time to be having these conversations. If you're an agent that is here on this class and your broker is not, perhaps reach out to your broker and say, hey, look, I'm a little uneasy about using these forms. What are we supposed to be putting in these defaults? Do you have a preference? Have you thought about it? Should we do some training on it? Ask those questions because it's going to help you in the long run. Also, you don't want to have to completely fill this form out for every buyer every time. You would prefer, conceivably, to know exactly what goes in those defaults and just change the name, and that's pretty much it, right? You want to streamline the process a little bit. Are you not sure how to talk to a buyer about the NAR issue or how to approach them with the EBBA? That's something you got to talk to your broker. I have an opinion on that, but very much something that is unique to the relationship between the broker and that buyer or consumer, excuse me. And then the other thing is, if you are here and you're like, okay, fine, I got 3 weeks, I got 5 or 6 buyers that are going to hire me between now and then, whatever, I'm just going to show them the houses. You don't technically have to have them in place until the deadline, but I would say use this as a safe space to experiment and acclimate yourself with the EBBA before the deadline comes. Work with them and experiment having those conversations with these test buyers, so to speak, so that you become more familiar with them, so that you have those office policies in place, so that come August 6th, you are hitting the ground running. Okay. That is it. That's my contact information. I left a few questions unanswered. Kevin, if you can assist, that would be great. I'm going to pick up with Diana Peters' question at 12:25. This is a long one, but with regard to compensation, in a scenario where the cap for commission is listed at 2.5 on the EBBA, in the event that the buyer pays that commission, but the buyer is interested in a new build and the builder is offering 4% commission. I'm going to stop right there. All of this EBBA stuff has language that a lot of people overlook, which is MLS participants. Okay. And what that means is properties that are listed on the MLS are regulated by this practice change. Properties that are not listed on the MLS are not regulated by this change. So a new home construction like, building from dirt, lot premium and the whole 9 yards, right? Choose the model, the whole shebang. That's not governed by this stuff. So that relationship between buyer, broker, and builder is going to carry on exactly the way it was. The only scenario where new home construction spills over into this stuff is on the off chance where custom home builders, some of the smaller builders, they build and they don't have this massive in-house sales or leasing team. So they engage a listing agent to list, and then they list on the MLS. Or large builders sometimes will take some spec homes or inventory homes, and they put them on the MLS to gain attention. So in those scenarios, yes, it applies. But I'm going to finish answering the question. So the question is, but the buyer is interested in a new build and the builder's offering 4%. How do we handle this? We often don't know the commission, if any, is being offered. So like I said, if it's a true new home construction relationship, it doesn't matter. You handle it the same way that you did before. The only scenario, let me take that question and change it a little bit to answer what I think is a plaguing question for everyone else, which is, what do I do if my buyer's broker agreement says I'm capped at 2.5, but the seller actually is offering 4, right? What do I do? Remember what I said earlier about not selling yourself short? Right. This is where it comes in, right? So the likelihood that you're going to get a 4% and you put 2.5% probably doesn't come too often. I don't know, actually. Maybe I'm speaking out of turn. But my point is this, right? You have to have, that's why that call before you do the showing is so important to the listing agent. That's why it's so crucial to communicate. And that's why it's so super crucial to get it in writing, get them to send you the seller signed commission agreement. That sets out how much they're offering. So you know right away how much they're offering. And you know right away, if that number is more than on your buyer broker agreement, you have a decision to make. Now, some brokers, particularly at FLA21, I encountered this question a lot, which is, well, if we find out that they're offering more, can we modify the BBA? Yeah, you could. I don't like it because it telegraphs, or at least you're creating a paper trail of circumventing this rule that obviously was intended to keep commissions a little bit more affordable. But nothing in the world says, and it's not illegal to engage in good faith modifications of buyer broker agreements. So if you're going to get 4 from the seller, you can go to the buyer and you can say, hey, look, it says 2.5, but I can only get 2.5. But they're going to be paying 4. They're not going to give you the extra 1.5. So can we modify our agreement in good faith to say 4, and then I get the 4? Nothing wrong with that, so long as it's fully disclosed, and protect yourself, and obviously do that with broker supervision. Diana, that question was not the question you asked, but I think it's the question that a lot of people were wondering. So forgive me. I hope I answered your question directly. I see a little emoji, so I assume I did. All right, Kevin, what do we got next?
What happens to existing MLS listings showing compensation at the time they go into effect? The selling broker creates the compensation form and it has it signed.
They explode simultaneously. They explode out of
yeah, like Mission Impossible, right?
It self-destructs. No, what I think is going to happen is that probably at 12 o'clock a.m. in 1 second on whatever, August 6th, right? The fields are just going to disappear from the MLS. So that information will just automatically be removed. It's my understanding there's no affirmative act that needs to be done by any listing agent. MLS is taking care of it for you. Those fields are disappearing. So,
there was an email that came out. I think it was a misfire because they recalled it last week or earlier this week. It kind of burst together with the event, but that you had to remove any offers of compensation from your listings by the 17th. Anything in the MLS, including like if you have your realtor marketing like that, would incur an auto fine after that.
Right. Yeah. So, but I feel like, like the text fields, that's a coding thing, and that's how the MLSs are going to resolve it. So I'd be very surprised if they needed every listing agent to remove the information in order for them to remove the fields. I feel like it's the other stuff, the attachments, the statements in realtor remarks and showing time that they're really talking about.
Yep. The next question is from Mark Paris. Is there a new listing agreement that ties into the compensation agreement, seller's broker to buyer's broker and/or seller to buyer's broker?
I believe so. I mean, it hasn't been released yet, but I believe that there are new forms coming out. There's
Later
a lot
this
of,
month.
yeah, there's a lot of talk. That said, I was originally expecting these documents to come out. That came out on July 9th. I was expecting them sometime in June. They didn't come. But I do expect that there's going to be another series or another wave of documents that kind of complement the list side of this whole thing.
Nancy asks, a good one. If the listing broker has a listing agreement signed by the seller agreeing to offer co-broke of X% to a buyer's broker, and the EBBA says less than X%, with the cap, what happens to the difference? So, I mean, obviously it's, we'll have to see how the new listing agreements worded.
I wasn't great at algebra, so let me process that a little bit. So listing agreement says
5%. Yeah, and the EBBA is less than that. So now the listing broker's agreed to pay a certain amount of money or co-broke that amount, but the buyer's agent EBBA is less. What happens to the difference? I'm assuming the listing broker gets to keep it.
Yeah, I think so. Which indicates here that if you're a buyer's agent and you have that disconnect, right? It's to your benefit to resolve that disconnect in writing sooner rather than later. Because yes, your buyer, the amount that you can collect on the buy side is going to be capped on your EBBA, which in that scenario is going to be less than the seller's offer of comp.
And obviously we'll have to see the new listing agreement when it comes out. And that, last question was coming in from Ronnie. Can we place in additional terms that if the seller pays X%, buyer pays Y%?
So, Kevin, you've heard me say this a lot. And anyone that has been on my classes, I always say this about additional terms, special clauses, other stuff, the blank space, right? Florida Realtors, Joanna Watkins is a brilliant attorney. She's general counsel for Florida Realtors. She painstakingly works to make sure that these forms are to your benefit. And they're pretty darn good. So I like to joke and say, well, if an agent is going to take a near perfect uniform form and just put a bunch of stuff that they think is right down at the bottom, it's kind of a way to, it's a fast track to a crime, basically, to commit unauthorized practice of law, because you don't know if what you're doing is going to adversely affect the rights and the legal rights and obligations of the parties involved. In fact, based on that, they probably would. So I always encourage agents and brokers, do not do this. If it's something that is going to be done at a brokerage level, consult with your general counsel so that the attorney for the brokerage is preparing the specific language. And then it's just cut and paste every single time the document is prepared. But I don't like this idea of placing conditional terms for a couple different reasons. One, that to me flies in the face of one of the requirements of the NAR settlement, which is that the amount to be compensated on the buy side is definite. That's conditional, right? NAR settlement clearly says the amount that the buyer's agent is going to be paid has to be specific and how it has to be calculated. To me, this language would conflict with that settlement obligation and say, well, we're supposed to be paid this up here in Section 7 compensation, but down here it says, if this, then that. That's flexible, that's changeable. That to me is a violation of the NAR settlement terms. So I wouldn't do it.
I think the law field is going to make a lot of money.
Like I said, I'm waiting to move to the Cayman Islands. But yeah, another question popped up. Buyer's agreement would be modified by the seller's signed commission statement. No, not automatically. Whatever the commission agreement is between the seller and the buyer's broker, or the seller's broker and the buyer's broker, that's contract between those parties. A change in one doesn't automatically modify a change in the other. It doesn't just do that. It needs to be done by the parties who executed the agreements. So they don't automatically modify. You may end up choosing to modify your buyer-broker agreement with your buyer after a good faith conversation about it, after receiving the seller's God, I sound like such a lawyer here. But you may choose to do that and change and modify your buyer broker agreement with your buyer based on the information received from the seller in their commission agreement.
Excellent. Crystal clear. As we used to say, from Louisiana, the Mississippi River is too thick to drink and too thin to walk on, and that's about where we're at with the law that's evolving around this. Jesus, have a listing that is teed up to go live tomorrow. Do I have to? Nope. I'll cancel that. Do I have to craft a new compensation agreement? Again, this does not go into place until the 17th, and hopefully we'll have that one. He's one of our agents, so I'll take care of that with you, Jesus. And then will there be a recording? Andrew, are we able to release a recording? Are you okay with that? Or
yeah, as long as everyone is super crystal clear, and because it's being recorded, I'm going to say it again. Everything that we have talked about here is informational and educational purposes only. It is not to be construed or interpreted or used as legal advice as to any particular scenario, situation, objective, contract, or relationship. And every comma, every period, every number, every term in an agreement has meaning and significance. So it can't ask you, and definitely don't want you to take what we talked about here today and then put it into practice, and then something goes wrong and say, well, Andrew advised me to do that. No, Andrew didn't advise you to do anything. Andrew taught you what the new forms were, and you chose to do that. So that is, that's that. But with that, I have no problem sharing the recording.
Awesome. And so we'll get the slides out and a link to the recording out as soon as recording is done processing. And if you have questions, you can always email in, and we'll get those over to Andrew, and Andrew's information, reach out directly to him. But I know we're over on time. Real quick, just a quick announcement. We got a lot of feedback from FLA21. A lot of folks said they had FOMO. They didn't come because they thought it was only for Florida. And I'm like, no, this event since 2018 has been open to any Century 21 affiliated agent, office manager, staff, whatever. As long as you're part of the brand, you are cool to come. So we're making some changes for next year. First change on deck is we are actually going to be moving this shindig. Next year, we will be at the Hilton Walt Disney World, and that is right across the street from Disney Springs. So you can literally walk across the pedestrian sky bridge right there and be at Disney Springs with all the entertainment options and such going on down there. So just a great location. And to make sure it's clear how much we're going to be elevating this event, we're going to be plussing it up like crazy. So taking it to new heights, including making sure people know that they can come. Starting next year, FLA21 will be known as Elevate21. So that is our new name starting next year, Elevate21. The dates, arrivals on the 20th of July, departures on the 23rd of July at the Hilton Orlando Lake Buena Vista, open to all Century 21 affiliated brokers, agents, and staff around the world. And we got a lot of things. We're expanding it. Everybody told me it was too quick. I didn't get one person that said it wasn't. It was too long. Everyone said we need more time. So we're going to a full 2-day program. So all day Monday, all day Tuesday. We're going to be including breakfast and lunch catered for everyone. That's going to help with making sure that everybody can get from morning sessions to afternoon sessions without the hotel staff having to turn around. So we'll have that done. We're also going to be introducing, if you went to 121 this year, those interactive mini learning session demonstrations in the Industry Connect Hall. We're going to be having those next year. And one of the biggest requests we had was more Spanish classes. So we're going to have a dedicated Spanish track of learning at this event. So it's going to be incredible. Tickets will go on sale next week. We'll send an email, and everybody that attended FLA21 this year will get a discount code to be able to bounce back at a discounted price for next year. That'll be available for the first 14 days after tickets go on sale. So be on the lookout. By Monday of next week, you'll have that in your inbox. Check it out. We hope to see you there at the Hilton Lake Buena Vista. It's going to be incredible. Trust me, we're definitely going to stick to our name and live up to, and it's going to be an elevated experience. So we're looking forward. Thank you for participating this year. Thank you for being on here today. We'll wrap it up, get you back to your day. If there's any questions you have for Andrew, you can contact him directly or just reply to the email we've sent, and we'll get those questions answered for you. Have a great day, and we'll see you real soon.